Crowther and Dan Clarke are going to talk to you about Forum Non Conveniens. Where are we now? To which, of course, the answer very often is not where we want to be. And I knew you were hiding at the back there, Sarah. I don't need to introduce either Sarah or Dan Clarke. They are very much the A team in this. Sarah, Deputy High Court Judge, a number of outstanding cases she's been involved in, and Dan Clarke likewise.
Well, thank you all very much for coming to our welcome to our talk, Forum Non Conveniens, Where Are We Now? Very nice to see you all in person. It's very nice to have managed to get back in the room as well. So that was very tense. That was very tense. And hello to everyone who's watching remotely. So in this talk, I'm going to be talking about recent developments in Forum Non Conveniens, where we are now, and possible future developments. And Sarah's going to talk about some practical points. We will be touching on the gateways as well, but because you sort of have to really when you talk about Forum Non Conveniens, we're not going to go into the gateways in a huge amount of technical detail that we needs to hit. Now, because you're all experts, I don't need to go into the history of Forum Non Conveniens or restate it in any great detail. Like a lot of really useful inventions, someone Scottish invented about 100 years ago. And it's the inherent discretionary power that the English court has to stay proceedings. In an appropriate case, stay normally almost always means stop completely rather than leave on the file in this context. And although it was invented over 100 years ago by the Scots, it took about 100 years to catch on in this country. And for a very long time, the scope of the power was viewed very, very narrowly indeed. And it started to become more liberally interpreted. And then eventually, in Spiliada in 1986, it got the definition, which it still has, which is essentially a stay may be ordered where there is some other available forum of a competent jurisdiction, which is the appropriate forum for the trial of the action, i.e. in which the case may be tried more suitably for the interest of all the parties and the ends of justice. Now, the name Forum Non Conveniens suggests, a lot of people assume that it's all about finding the most convenient place to try an action. Now, that is very much part of it, but as the definition in Spiliada tells you, it goes a lot further than that. The test is appropriateness, of which convenience is just part. And what the court's really trying to do, the question it's ultimately answering is, what is the natural forum for the trial? What's the centre of gravity of the dispute? Which countries, which jurisdictions, courts does the case have the most real and substantial connections with? Those are all the sort of epithets or descriptions that the courts tend to use when they're summing up what the test is all about. There are two further really important aspects of the test, and they are the standard that you have to reach and the burden of proof. Now, the standard is that the forum contended for must be fit an alternative, or it must be clearly or distinctly more appropriate. So not just more appropriate, but clearly and distinctly more appropriate. And that can be crucial, and it often is crucial. In the Clarke case, which I heard Sam talking about earlier, in the judgment, Master Dackle said if it had just been a case of which was the appropriate forum, then it would have been France. But actually, because the test was clearly or distinctly more appropriate, it turned out that it was England. So it made, in the end, all the difference in that particular case. The other aspect is the burden of proof. In a case where the defendant is served in England as of right, and they're contending for jurisdiction in another jurisdiction, then the burden is on the defendant to show that the other jurisdiction is clearly or distinctly more appropriate. In a case where the defendant is served, service out case where the defendant is served abroad or overseas, then the burden is on the claimant to show that England is clearly or distinctly more appropriate. And again, given the high nature of the standard, it obviously really matters which party bears the burden. So just when you thought you got through the test, then you get to the second limb. And I like to think of it a little bit like Fergie time. There may even be people who are not old enough to remember Fergie time. So another way to look at it, another perhaps even more dated reference is it's a bit like that line from The Godfather when he says, "Just when I thought I was out, they brought me back in." So if a party manages to show that there is prima facie another forum that's clearly the more appropriate one, a stay will usually be granted unless the claimant can show that there are circumstances by reason of which justice requires the stay should not be granted. What does that actually mean? I mean, in practice, what it means is the claimant can point to that other jurisdiction and say, "I'm not going to get a fair trial there. I'm not going to get justice." And that, I mean, this is something that is not litigated very often in personal injury claims, but it is litigated a lot in gloves off commercial litigation, and it tends to mean that the claimant has to show that the judges are going to be biased, or that there's going to be an exorbitant delay that will mean there's no justice, or there's an immunity from suit for a party that would otherwise be liable, that kind of thing. In theory, it's no reason why it couldn't be deployed in a personal injury action. When I gave a talk last year about forum non conveniens, oh, hello, look. My Siri's trying to talk to me. When I gave a talk about forum non conveniens last year, I speculated that we've now opened up the possibility that you can argue that you won't get justice in an EU country, but the chances of that happening seem pretty slim. It's a pretty high threshold to cross. So where are we right now? Well, immediately before Brexit, forum non conveniens applied in non-EU cases, but it's been banished from the Brussels regime that applied to EU cases. And the leading case on that was, of course, Russo and Jackson, which is a personal injury case in the CJEU. And it did apply, of course, in non-EU cases, as I say. But then on Brexit Day, at the end of 2020, we fell out of the Brussels system with a resounding thud, and I think not without a little buyer's remorse of the frantic attempts to accede to the Ghana Convention, I think, to go there. And that meant that in EU cases as well as non-EU cases, we reverted to the common law. So forum non conveniens now applies, with some exceptions, pretty much across the board in personal injury and in all actions. In many situations where it didn't before, in particular in cases involving EU defendants. So what that means is, whereas before in EU cases where jurisdiction was a lot of the time was as of right, or at least there was a yes or no answer, now it's a discretionary and live issue in far more cases, and many previously clear-cut cases are now either way cases. A claimant now typically needs to apply for permission to serve out if they're trying to sue an EU defendant in the English courts, and they have to prepare for a challenge to jurisdiction on forum non convenient grounds. And defendants are presented with a perfectly legitimate opportunity to challenge jurisdiction on forum non convenient grounds in EU cases, and either stop the case dead in its tracks or at least divert it to another jurisdiction. Now, there are some important exceptions. Even before Brexit, there were the convention cases, so cases falling under Montreal or Athens. They've got their own jurisdictional regime, so that simplifies that. That carries on. Package travel is, to all intents and purposes, immune from this. Almost all package travel terms and conditions have jurisdiction clauses in favour of the English courts. And anyway, to allow forum non conveniens challenge in those sorts of cases would drive a coach and horses through the legislation, the whole point of which was to bring the consumer's right to sue home. So that all carries on. There were then the exceptions which came at the same time as Brexit. So at the same time that we fell out of the regime, there was a sort of slightly kind of, it seemed anyway, slightly desperate attempt to sort of carve out from the consequences. The first carve out being the consumer contracts jurisdiction, which is almost word for word imported from the Brussels regime into English law by virtue of Section 15 of the 1982 Act. and the employment contracts exception, which does the same thing. Now, those are both potentially extremely useful jurisdictions for claimants in PI, cross-border PI cases. One thinks of excursions applying to consumer cases and claimants working abroad and in employment cases. What do they actually do for you in terms of forum non-conveniens? I mean, certainly they mean that the claimant doesn't have to apply for permission to serve out in the first instance, so they can just serve out as a right. And as a consequence, that I think that means that it's the defendant served who has the burden of showing that they're not being sued in the right jurisdiction. So that's very helpful. It's not completely clear whether forum non-conveniens is completely banished from those sorts of cases or not. My view is that probably it isn't, and it's still open to a defendant to argue forum non-conveniens anyway, but it hasn't been settled. And there are one or two reported cases about it, but I don't think any of them confront that issue. So the answer is they do present an advantage, a sort of, but they don't completely sidestep forum non-conveniens. It's still there. The other exception, which came slightly after Brexit Day, is the jurisdiction agreements. Not like something that's likely to come to great deal in personal litigation, but it does sometimes. But again, it's the same scheme. What the legislative change does is you don't need to apply for permission to serve out, but it doesn't mean that forum non-conveniens has been banished completely. So just sticking with legislative changes, we're looking at the cases. What is coming up as regards to that? Well, I mean, as far as accession to Ghana goes, that looks like it's dead for foreseeable, because the European Commission's basically not so much said go away from back in the day, it's just go away. In terms of further internal changes, that they seems likely, but it's difficult to say exactly what form they're going to take. And there are three possible sources for further change. The first is the Civil Procedure Rules Committee. Now that's obviously that's the body that's set up by statute to keep the CPR under review and propose changes to the CPR. The CPRC has set up a subcommittee just to deal with service, so essentially with jurisdiction. And the most recent, I mean, we obviously had the consumer contract and employment changes, which the CPRC sort of put through, which I've already mentioned. But the most recent changes that the subcommittee have made have been to the gateways, and those came into force in October 2022. Now, those were relatively limited. If you look at the minutes, the remit of the subcommittee was really just to sort of look at tidying up the drafting rather than doing anything too drastic. But anyway, they did that. There are some helpful changes in that. One of them being tidies up the contract gateway, so that's sort of less fiddly. That may be helpful in some personal injury actions. But the one thing that does come across quite clearly from the minutes is that the subcommittee has not been stood down. It's got further changes in it and further projects in this area to come. It just doesn't say exactly what they're going to entail. So I think you could read into that there's likely to be some change, probably along similar lines. In terms of how it's going to affect FNC, I don't think there's going to be a sort of head-on confrontation with the doctrine, but the scope of it's likely to be reduced further by further changes along the lines of those that we've already seen. Not least because the falling out of the European regime means that there's a really high burden on the High Court now, trying to deal with applications for service out and forum non-conveniens challenges. And if there's obviously a drive to try and reduce that a little bit through legislation or the scope for it anyway. So you've got the subcommittee there, which it seems likely there's going to be more changes. In addition to that, you've got what is normally called the Mance Committee. That's the Lord Chancellor's Department's got an advisory committee on conflict of laws, which Lord Mance chairs. that seems to have a much freer hand, and its remit is much less clear. But one thing is clear: it interacts with the subcommittee that I've just mentioned, and they consult with each other. So that seems likely to be a sort of another driver for change in the area. The third source is the academic one, which is Adrian Briggs and Andrew Dickinson, the All Souls College Oxford professors. Now, they have actually produced something which directly confronts this issue. They've produced a paper with a draft statute in it. I mean, I'm not going to try and summarise it all, but in very broad terms, one of the things it does is abolishes the need to apply for service permission to serve out in the first place. So they just get rid of that sort of aspect of the process completely. You just serve the proceedings, and then it's up to the defendant to challenge it. I think that's something I'm not quite welcome by a lot of people, because it becomes very burdensome and fiddly, and also a bit of a sort of nonsense, because very few applications to serve out, which are almost always done ex parte, are refused. They just seem to go through, and the real business happens later when there's a challenge. So that's one proposal they've made. The substantive proposal is that there's going to be a list of two different lists of gateways, A and B. And if you fall into a list A gateway, then you've got jurisdiction, and that's the end of it. Okay, no more discussion. If you fall into list B, you might have jurisdiction, but you've got to show that there's a real and substantial connection to the jurisdiction to justify it. So there's sort of, you need to fall into B, and then you need to satisfy this further requirement. And then list C is a sort of list of forum non conveniens type reasons that can apply to list B cases, if that makes sense. It's an interesting scheme. I mean, I'm not going to go into huge detail about whether it's good or not, but I think you can, if you were to make a criticism straight away, you would say having a scheme where you're still having to assess at the gateway stage whether there's a real and substantial connection with England seems like it's going to unearth pretty much all the same arguments we're already having. It's not going to make things much simpler. And then you've got to go on to what is a sort of forum non conveniens stage anyway. So whether it's likely to simplify, which is the real sort of thrust of the proposal, I think that's, well, so it's a question to say that. The first thing I did when I read their paper, which I think everyone here would probably do exactly the same thing, was I immediately went to the tort gateway and thought, what would have happened if this had applied in Brownlee or in any of the other cases that we deal with all the time. Interesting. I mean, that's all. I reckon everyone here would have done that. Interestingly, what it says is not sort of drastic. They've actually kept the tort gateway that we already have in exactly the same format, pretty much, but they put it into list B. So if Brownlee were to have happened, or a similar case would happen now under these rules, you would go to list B. You would say, oh, okay, well, it falls within list B because damage is defined the same way. Haven't reversed that, but then you would need to prove there was a real and substantial connection with England before you got to the forum non conveniens stage. There's an extra hurdle put in your way. Whether that's useful, I don't know. That's what they've done, and the reason they've done that is that certainly Professor Dickinson, and I think possibly also Professor Briggs, felt strongly that that Brownlee was too broad. Because all you need to show is some damage that's more than de minimis, and they thought that was just too broad a gateway to have, so they wanted to narrow it. Anyway, that's the proposal. Whether any of this will become law, I don't know, but it will certainly be taken seriously. And if they're boring enough to read the minutes of these various bodies, they do sort of all interact with each other. And take interest in each other's work and consult with each other. So there's no question but that it will be considered at some point, I think. And we'll just have to see what comes of it. Right, so the last thing I want to talk about is just briefly about some of the recent cases before I let Sarah take over. Now, forum non conveniens is something that's litigated extensively, especially in commercial IP and competition actions now, as well as PI. And there are a huge number of cases going about. And they all turn on their own facts. So and the grand principles are the ones that I've set out at the beginning of this talk. There are many other grand principles to extract from them. So there aren't any silver bullets, but there are useful steers and useful indicators to take from looking at this kind of thing, and they give you a sort of idea of how various arguments might go down or do go down in reality, but they don't necessarily give you anything sort of firmer than that. Now, Cleaver and Slater, I heard Sam talking about that earlier. He deferred to Will Young's masterful description of that and an explanation of that, which he gave last year, and I'm going to do the same largely. No one will ever do it as well as Will did it. It's on the internet. In fact, if you Google Forum Non Conveniens and put it into YouTube, it's almost the first thing that comes up, which is fantastic. So very easy to find. I mean, yeah, I'm not going to say very much. I will say one or two very short things. I mean, that was a skiing accident in France where the claimant, slightly unusually, the claimant lived in France and the defendant in England. Now, the claim was permitted to proceed in England and Wales. It survived a Forum Non Conveniens challenge. What you could take a lot from it, because it's quite an extensive judgment and a lot of very detailed and careful analysis by Master Dagnall. But in short, the points I would pull out from it are the fact that liability was admitted was actually the key in the balance. The fact that there had been litigation, or the claim had sort of been running along in England, albeit pre-action, for 2 years, was another thing that the Master thought was really important. So sort of the fact that the parties have been engaging with each other in England for quite some time was another really important factor. The potential enforcement difficulties of a French judgment in England was another factor that weighed very heavily. The fact that, as I've already alluded to, that the burden, the standard being that France had to be shown to be clearly and distinctly more appropriate, was quite possibly determinative. And the other interesting thing to come out of it is the second limb, which I mentioned earlier, which is usually seen to be something very narrow and requiring really kind of quite striking defects in the other jurisdictions system. Master has quite a broad view of that, and lots of much milder factors were kind of considered under that head than would normally be the case. Now, whether that's something that will catch on, generally, I don't know, but it's an interesting feature anyway of that case. So that's Cleaver and Slater. Second case I wanted to mention was Samsung. And now you're probably thinking, Samsung, personal injury, we're personal injury lawyers, what are you talking about? It is a competition claim. And so, yes, but that doesn't mean there isn't something useful to take from it. So essentially, all of the parties in this action were companies that were based in South Korea or Taiwan. They've all been found guilty by the European Commission of a price-fixing cartel to do with LCD screens. Samsung was sued by various English local authorities and had to settle for millions. And then wanted to bring contribution proceedings against the other two parties in England. And there was a Forum Non Conveniens challenge. Now, ultimately, the English proceedings were stayed, so that the challenge succeeded. But I think what's interesting to take out of it for us is two things. The first being that the big point that the claim that Samsung had was that they'd been in litigation, if not arising from exactly the same facts, and at least arising from similar incidents, and raising pretty much the same kinds of issues for about 10 years in England before this. And that hadn't weighed in the judges' or very enough in the judges' assessment. And what was said about that in the Court of Appeal was, well, yes, but you didn't really provide any proper evidence of that. So it's no good just asserting in in submissions that we've been in litigation with you for all this time and so on, and therefore we should keep litigating in England because we'd be starting from scratch if we started litigating in South Korea or Taiwan. You have to evidence it, and they hadn't actually evidenced it. So it's quite a strong hint of the judgment that had they managed to do that, that might have made all the difference, and they would have won. So that's sometimes called the Cambridgeshire factor. The fact that you've already been litigating in the or very similar action previously and starting from scratch in another jurisdiction would be wasteful. So they had a Cambridgeshire factor point, but they managed not to take it below, and that was, that's, it doesn't say explicitly, but on the face of it looks like probably the losing of it. The other point was the main action, which had been between the English local authorities. Well, I have to say I don't know exactly how that came to be, but anyway, between English local authorities and Samsung, that had been litigated in England, and Samsung took a point saying, well, that didn't weigh heavily enough either. What the Court of Appeal said about that was the fact that the main action had settled. It meant that it was really quite marginal relevance. So, whereas if it had still been going on, that would have made a huge difference. Now, that's relevant for us because it's not uncommon that parties are bringing contribution claims arising from the settlement of a PI claim, and they might want to do it in England. What's interesting is the Court of Appeal didn't think that. The Court of Appeal said essentially, well, look, the fact that the main action is settled means that's sort of history now, and it's only of marginal relevance. We're dealing with this action, whereas you might have thought that it might have had more relevance than it does. One of the complaints that Samsung made was that disincentivizes people in their position from settling, because they're then disadvantaged in the contribution. But anyway, that was the approach that's taken. Charlton and Defert is the sort of classic scenario of an RTA in France claimed by an English driver against a French driver, liability and quantum in issue. This one ended up with Master McLeod saying that it could stay in England. What to take from it? Two things. The first was the defendant had agreed to accept service by solicitors in England in this case. There was a big, really quite lengthy argument, it seems, about what that meant. And it was being argued by the claimant that it meant that the defendant had submitted to the English jurisdiction and couldn't raise Forum Non Conveniens at all. Anyway, the answer was they could still contest jurisdiction on that ground, but it simply meant that the burden was now on the defendant as opposed to would have been on the claimant.
Can't be right.
Yes, I don't think it's right. So it can't be right. I agree. I don't think it can be right. But anyway, that was the judgment. It's not really clear whether that made a difference to the outcome or not, to be honest. But anyway,
So the burden depends on whether service is in or out as of right. So if a defendant offers effectively as a courtesy to instruct solicitors to accept service on their behalf outside, it's a deeming kind of service. You're still serving out.
Yeah. What Master
Can't
McLeod
possibly
said about
affect
that
the burden.
was that it had become a service in case because they'd agreed to accept service.
That's not.
So that's
Sorry.
Well, there you go. That's what happened there. So you could read the reasons that are quite negative. Yeah.
The bit where she says that you can only challenge four of it, but not the other two other bits of the gateway and the merits test or services accepted. She said she wasn't looking at Forum as the 1, 2, 3. She was looking at jurisdiction. And I like it's a bit.
That's also novel. I've never seen it. I've never seen that done.
Yeah. Anyway, it's quite interesting that the sort of, when you get to the actual factors, the sort of bit that normally takes up all the space in Forum Non Conveniens case is very, very short. And what she said essentially was that, well, it seems like the real complexities in this case are in the quantum side. The complexities of quantum comes before more than any other particular issues of liability that to be tackled in English court. So that's where it should be litigated. So, but it's quite interesting because if you look at the factors, seem to be some quite compelling factors pointing towards France, but obviously where the accident happened, French law applies, where the witnesses were, difficulties in summoning the French apparently important witnesses. I mean, those all points to France. And England, really, it was where the claimant lived and where his injury was sustained and where the medical experts would be if it were the case in England. So it's an interesting way to look at it. I mean, she obviously took the view the centre of gravity in this particular case was in England because the quantum issues were the most sort of taxing ones. If you compare that to the last case, which is Moore and Massif, which is Judge Hellman in Mersey City, different approach. So same basic facts, opposite outcome here. Now, we didn't have the complication of the argument about who bears the burden and have you been served in. So this is a service out case. So it's not said explicitly anywhere that was determinative. But anyway, it's a service out rather than service in. Broadly speaking, similar factors otherwise, but a very clear conclusion that it should be litigated in France rather than in England. The key points in the judgment are you always try and see, grasp the sort of key points because there's always a big list of factors on each side, but the really sort of determinative ones, the hinge ones, seem to have been the application of French law. French courts are better placed to examine concepts such as consolidation, future deterioration. So, as regards quantum, interesting because that factor had been present in Charlton and had not weighed at all really in it, but that was central here. Two other things. Firstly, the claimant would not have to attend trial in French proceedings. Now, there's specific evidence given about that, expert evidence. Not something I've been aware of previously, but that was said to be a factor pointing towards France. That the claimant, the English claimant, wouldn't need to go there. But I've not seen that in other cases as a factor, but there you go. Said to be important here. And the final point was the English proceedings hadn't advanced particularly far, so there was no sort of Cambridgeshire type point in this case. Those are the sort of real clinchers. But interesting. This was a relatively low value case as well. And it may be, we don't know much about the quantum in the other case, but it may be that because the quantum is small here, that didn't weigh so heavily in the balance. But on the face of it, very different approaches, which just goes to show that Forum Non Conveniens is very much a case by case jurisdiction. Sarah.
Shall I have the clicker?
I will surrender the clicker to you.
Thank you. Okay, right. I've got 1 minute.
Oh, I'm so sorry.
The good news, guys, is that everybody who's here, I'm gonna offer. If you've got, basically, I was going to talk about the practical aspects of it. So, if any of you have got cases that have got issues, I'm going to be out having a cup of tea in a minute with you all in 30 seconds now, so you can pigeonhole me. So I'm not too worried. So I was just going to buzz through a few practical issues. I think the headline for me is that Dan's completely right that in real terms, these applications that are made at the beginning for permission to serve out generally go through on the papers without too much hassle. The problem is that later they come under great scrutiny and they are ex parte applications or without notice applications in the not too modern parlance, and therefore you have to make sure that you've done everything under full and frank disclosure. You are effectively front loading your entire case. Picking up Karen's point from before, it's not just about have you got a gateway and can you set out a list of factors which would satisfy a Forum Non Conveniens test. You've also got to be confident of your causes of action, that they match up with your gateway, that you have identified the correct defendant. I know these are all basics, but basically what you're doing by serving out is you're giving the defending party effectively a kind of free hit on the whole claim. I mean, the submission I made in the Supreme Court in Brownlee was it's kind of buy one, get one free. You have your jurisdiction challenge, but you get a kind of free strikeout application chucked in at the same time because they get to say, well, is there any real prospect of success on this claim? Yeah, the Supreme Court judges had no idea what buy one, get one free was. I don't think they've ever been in Tesco's. I'm not going to dwell on all of these things. one of the big things that we lost post-Brexit was actually not so much the jurisdiction regulation, but the service regulation. It is really important that you think carefully and early about the practicalities of service, and that you don't skimp on it, and that you do make sure that you've done it all properly. If you are looking for extensions of time for service, they're one of the things, along with moratoriums on limitation, the two things that gives me sleepless nights. People applying for extensions of time for service of claim forms. You need to get on with it. If you are doing it, you've got to be so careful. It's such a dangerous territory to get into, because subsequently all of that can get reopened by the party that's been served. And if there's anything that's gone slightly awry or wrong in it, then the whole thing comes tumbling down. So it's a very, I know people have busy practices and service can be difficult, but it is a really difficult thing to get into. So try not to do it. And if you are challenging jurisdiction, it comes under part 11. That's why I don't really understand, if that's right, what Mr. McLeod said about there being a jurisdiction challenge where you only look at kind of the FNC parts of it, not the other bits. If you've brought a part 11 jurisdiction challenge, you've got to fulfill the three parts. You've got to have a gateway. It's got to be the proper natural forum for the proceedings, and there has to be a reasonable prospect of success. In fact, there is a residual discretion in the court, even after all those three, to refuse jurisdiction if it wishes to. So you need to make sure that you've covered all your bases. That includes foreign law evidence. I think in this day and age, to have a claim which is running under foreign law, where you simply set out the bare minimum in the pleadings and kind of hope that nobody will notice the point, is extremely dangerous when you're applying for permission to serve out. Because if a defendant wishes to challenge and they manage to obtain some foreign law evidence that suggests that you don't have a claim, or it's more difficult than you may have thought, then you're going to be in real difficulty. So that's something else that you're going to have to front load. If you're on the claimant's side. If you're on the defendant's side, it's something to look very carefully at, because if the claimants have gone a bit light on that, there might be something in there that is helpful to a challenge. And then very, very finally, obviously, technically you could have oral evidence at a hearing. I've never seen it done. I suppose you could have it done. There's a question about whether quox applies if a claimant brings a claim and then is unsuccessful in a jurisdiction challenge. It's not dealt with in quox. I think the bottom line is that nobody drafting quox had even heard of jurisdiction challenges or thought of cross-border cases. But the list of exceptions, I think the better view is that it's probably exclusive. So I think it is difficult to say that quox doesn't apply where a claimant brings a PI claim and loses on jurisdiction. But it's up for grabs. I can see a court of appeal maybe going the other way on it if they were persuaded. But it's really that final point on the slide, and it picks up from what Dan was saying about the Samsung case, which is that your jurisdiction challenge is the first night and the last night of the show. You don't get a second bite of that particular cherry. So it's important that you've got all your evidence in your application and in any challenge up to date. That includes, I thought there was something on the slide there about foreign law evidence. Yeah, here on that slide, that includes getting permission to rely on any foreign law evidence that you want to in the jurisdiction challenge as well. And you might need to get directions for the management of your jurisdiction hearings. You might actually have to have a CMC about the jurisdiction challenge, which I think brings me back full circle, because when we were preparing for Brownlee, I think we read all the Supreme Court cases, and every single one of them kind of said, oh, these jurisdiction challenges, they all take so long and they're all so complicated. Why don't you keep them simple? But it's because of directions like that where people say, well, why don't you have a CMC and then foreign law evidence and all the rest of it? Anyway, that really is the whistle-stop tour. I mean, if anybody has any specific questions either about service or jurisdiction or about the practicalities of FNC, grab me in the coffee break. Thank you.